As AI tech continues to advance, it's raising very important questions in the arenas of intellectual property and of copyright law. Exactly who owns the rights to works created by AI, or even works created with AI, will most likely remain one of the most pressing legal and ethical issues facing publishing and the Academy for some time. So if you're going to teach and conduct research in the AI age, it would be wise to familiarize yourself with the basic principles surrounding these issues. Traditionally, copyright law has been clear on one thing. For a work to qualify for copyright protection, it must be original, and in most cases, defining something as original requires a human author. This means that in many places like the United States, Spain, Germany, other parts of the European Union, only works created by human beings are eligible for copyright. But what happens when AI isn't just a tool, like a pen or a word processor, but an active participant in the creative process? This is where things get tricky, and ethically, it's where they get very slippery. AI today can generate entire pieces of art, literature, and even music with minimal or no human input. For example, what if the AI is simply following the instructions of a user? Who owns the copyright to those works? Is it the user who prompted it and told it what to create? Is it the programmer who created the AI in the first place? Or should the AI itself have rights? These are important questions, and the law really hasn't answered them yet with much depth of clarity. The question of who owns the copyright to AI-generated content is largely unsettled. In the US, copyright law still requires human authorship, and ownership belongs to the person who first established creative control. In cases where a human's input is substantial, like if the person is providing detailed prompts or made numerous adjustments to AI content, that person's usually more likely to own the copyright. However, if the AI generates content with minimal human intervention, the work might be considered public domain, with no copyright protection available to either the user or to the developer. To make things more complicated, the law is still grappling with the role of AI as a potential author. Current laws do not recognize AI as capable of owning any copyright, meaning the AI itself can never have rights. The programmer who created the AI could claim ownership over the AI's underlying code, but not necessarily over the final products generated by users. So where does this leave us? Some recent developments suggest that these questions might just end up being decided on a case-by-case basis. Other scholars think that we're on the brink of writing entirely new laws and guidelines specifically for AI-generated works. One thing we do know for sure is that as AI continues to evolve, so too will the legal and ethical frameworks that govern it. So when you use AI, ask yourself, what information are you feeding into your AI? Is it something you have the rights to disclose? And critically, can you trust the AI's output to be accurate and not just a digital hallucination? These considerations help mitigate risks and ensure that your use of AI remains ethical. The dialogue is ongoing, and the landscape is changing rapidly. One thing we know for sure is that this is a very critical moment in the history of intellectual property.